Good afternoon, everyone. Welcome to the Laude and Valideus update from ICANN 64. Today is Tuesday, the 26th of March. The webinar will take about 30 minutes to complete, and it is also being recorded. Again, my name is Dietmar Lenden. I'm a Senior Manager at Valideus, and I'll be the moderator of this webinar. On the call with me today, I have Jeff Newman, USA SVP for Laude, Susan Payne, Head of Legal Policy, and Ashley Roberts, Senior Manager for Valideus. Just to give you a little bit of a heads up, the agenda for today is as follows. There's a little bit of an intro from me, which I'm doing right now, a brief status update on rights protection mechanisms and subsequent procedures. There's also going to be an update on the expedited policy development process, as well as Policy Development Process 3.0 and governance at ICANN. And then if we have time permitted, we'll have a Q&A at the end. Just a couple of housekeeping rules. If you have any questions during the session, please feel free to use the chat box, which you should have available on your right-hand side of your screen. Drop your question in there, and if we have time at the end, we'll get to answer those. If you have any issues during the webinar, i.e., you get dropped off or trying to log back in again, etc., please email info@valideus.com. And last but not least, a small disclaimer: we are not a law firm, and as such, we are not providing any legal advice during this call. We can answer queries without giving specific legal advice. So without any further ado, I give you Susan Payne and Jeff Newman, and it'll be a brief status update on RPMs and Sub Pro.
Hello, good afternoon, good morning, or good evening, depending on where you are. This is Jeff Newman, and I'm first on the timeline to talk about subsequent procedures. And being brief, we've updated everyone on previous calls about all the work going on with working towards the next round of new GTLDs. And so rather than focus on the substance of the issues, because we have an exciting topic to talk about a little bit later, here there are two timelines that we're going to show you of how long or when the subsequent procedures policy development process could be completed. The first one, as originally presented, as if you look at the timeline, shows us completing the policy development process by the end of, or it's actually towards the beginning or mid Q3 2019, and that's calendar year 2019. If you flip to the next slide, you'll see what we're calling a sub-pro timeline with additional public comment. So over the past several months, it has become a little bit more apparent to the working group that there may be some concepts or new ideas that lead to recommendations which have not yet been out for public comment. And the working group is in the process of evaluating whether some of those will need to go out for public comment. And as it is looking like right now, although it is not the leadership's decision of subsequent procedures, but rather the decision of the working group, it looks like there will be a public comment period on those items. And if that happens, then it's more likely to go on until the end of the year. And before I turn it over to Susan Payne to talk about rights protection mechanisms, just to talk a little bit about what that means. So if the group then does finish its work by the end of 2019, the next step is to deliver that report from the working group to the GNSO Council that's responsible for approving that report. And assuming it does approve that report in a timely fashion, it would get to the ICANN board at some point in either Q1 or Q2 of 2020. Once the board gets it, it has to do a public comment period, and then it could be in a position to approve the report. And if all the stars aligned and the board approved that report in let's say mid 2020, you're looking at probably about a year of implementation, or at least a year of implementation, in drafting the next applicant guidebook and potentially other aspects of the program. So it very well could be that the new program doesn't launch until the end of 2021 or the beginning of 2022, which would be approximately a decade after the launch of the last round in 2012. So with that, I'm going to turn it over to Susan Payne to talk a little bit about the rights protection mechanisms.
Thanks very much, Jeff. Hi, everyone. This is Susan Payne. Yes, again, just briefly going to touch on the rights protection mechanisms review. This being a review of all of the RPMs across all GTLDs, but being operated in 2 phases. So we are just going into the 4th year, I think it is, of the work on phase 1, and the phase 1 work is about the new GTLD RPMs. We'll get on to phase 2 when we finish that, and phase 2 is a review of the UDRP. As I said, I'm only going to briefly touch on it, but just to sort of give you a kind of highlight of where we are now. As I said, we're going into the 4th year. I would say we've pretty much completed the discussions we're likely to have on the post-delegation dispute resolution procedure, or PDDRP, which is a rights protection that actually hasn't really been used. And so there are no real recommendations, I think, coming out of the working group on that. We've also pretty much finished our discussion on the Uniform Rapid Suspension, or URS. And what will go into the initial report for the working group will be a series of recommendations coming out of some subgroup work, which I think really had good support from the working group as a whole, and then a whole series of individual proposals which have varying levels of support that the community will be asked to comment on. So when we do get to the point of the initial report going out for public comment, that will be an important time at which to submit views on those proposals in particular. At the moment, on what we're working on is we've circled back onto the Sunrise and the trademark claims. Having had some initial discussions on these, we then had quite a lengthy pause while some fact gathering and data gathering was conducted. And in the Kobe meeting, we, I think, actually started to make really sort of substantive progress on looking at the charter questions we were being tasked to answer and trying to answer some of them and think about what our recommendations might be. Obviously, those were the first time we'd started to have those discussions, so it's at a very preliminary stage. But you know, on Sunrise, one of the areas we were focusing on in particular was we spent a lot of time talking about Sunrise and premium name pricing. And how, you know, and whether that can be used to circumvent the rights protection or to circumvent the Sunrise, and the extent to which any recommendations could be made on that, bearing in mind that ICANN isn't meant to be controlling pricing on new GTLDs. But there was some good discussion on that and trying to come up with some solutions that maybe wouldn't go so far as to actually have ICANN mandating pricing. And in relation to the claims, we generally had, I think, a pretty good level of agreement in the group that we felt that the trademark claims was serving its intended purpose, which is to deter bad faith registrations, albeit that doesn't necessarily mean it couldn't do the job better. And although we didn't really have the data to give a positive indication of it, I think most people in the group felt that there probably were some unintended consequences in the sense of some good faith registrations possibly were being deterred. But we, you know, obviously there's more work to be done on that. And we also spent some time talking about the timing of claims notices and whether they shouldn't go out until after the registration process is completed, although most in the group really were in favour of keeping the timing as it is, and so having the claims notice go out before the registration of the domain name happens. Otherwise, it doesn't have a deterrent effect. To talk about the timeline, Jeff talked about the timeline for SubPro, and here's a slide that was shared at the ICANN meeting, trying to show the timings of SubPro and the rights protections together. Every time we have an ICANN meeting, the timeline for rights protection shifts. This is the latest. and it sees us putting an initial report out at, at the very tail end of this year. But looking at that and looking at, for example, the comparison of the timing of the initial report and dealing with any comments, comparing that to what happened on Work Track 5 in SubPro, Work Track 5 being a similarly sort of single topic area, if you like. I think that timing to me looks utterly unrealistic. The idea that in the space of sort of a month or two we'll have reviewed all the comments that we get back on these range of proposals and have come to a final report. It's at best it's being called optimistic, but I mean, to me it bears no real reality. But that's not necessarily something that matters so much, save that obviously the extent to which that interplays with the timing of subsequent procedures and whether it's necessary to have all of the work on RPMs wrapped up before the board could approve the subsequent procedures recommendations and move on to implementation. So that's certainly one of the things that people have been discussing a lot during the last few meetings. But as I say, that's just a really high level look at the rights protections. And I'm going to pass over to my colleague Ashley now, who's going to talk about the EPDP.
Thank you, Susan. So yeah, as Susan mentioned, I'm going to provide a brief update on the work of the EPDP. I'm going to start with just a short bit of background for anyone who hasn't been following this topic that closely. So go back about 9 months, and in response to the GDPR becoming effective, the ICANN board passed what's known as the temporary specification. This was applicable to all registries and registrars for GTLD domain names, and it allowed them to comply with the provisions of the GDPR insofar as they affected WHOIS requirements. So in a nutshell, what it allowed was for registries and registrars to redact certain contact information from the public WHOIS. Now, as the name temporary specification suggests, its term was finite. It was only permitted to last for a maximum of 1 year, and that 1 year term is coming up at the end of May, which meant that there needed to be a permanent policy developed to replace the temporary specification when it fell away, and to make sure that this conflict between GDPR and the old WHOIS requirements was dealt with. So for that purpose, to develop this permanent policy, the EPDP was chartered. For anyone that doesn't know, EPDP stands for Expedited Policy Development Process. And again, the clue in the name is that the idea was that this group would work at quite a quick pace to try and get this policy developed in a very short time frame by the time the temporary specification expired in May. So the work of the EPDP has been divided into 2 phases. Phase 1, which is what I'm about to talk about, was to look at the kind of fundamentals around what WHOIS contact data should be collected, processed, and then published in the public WHOIS. And then once that phase 1 work was complete, they were to move on to dealing with phase 2, which is to look at the question of access to certain redacted information for third parties. So the EPDP working group have worked extremely diligently and extremely hard over the past 6 to 9 months. And the product of their phase 1 work was a set of recommendations which were passed and approved by ICANN's GNSO Council quite recently on the 4th of March. For anyone that's not aware, the GNSO Council is ICANN's policy-making body. So I guess the important thing for all of you to know is what are the important things in these recommendations? What do they say, and how are they relevant for you as users? So what I've done, I've drawn out 4 recommendations which I think are probably the most important for people to know and understand. The first one's recommendation 10. This one outlines which specific existing WHOIS fields should be published and which ones should be redacted from the public WHOIS. And the kind of conclusion of this recommendation is that it's going to continue or kind of reaffirm what the temporary specification said on this question of what should be redacted and what shouldn't. For the registrant contact information, only the jurisdictional state and the country of the registrant are mandated to be published. The rest of the registrant contact information can be redacted by the registry or registrar. All of the contact information for the technical contact can be redacted, and they're actually going to completely do away with the administrative contact. Moving on to the next recommendation, I wanted to highlight number 13. This one specifically refers to the email address for the registrant. Now, recommendation 10 states that this email address for the registrant can be redacted, but 13 goes on to say that there still needs to be a way for third parties to contact a registrant anonymously, or sorry, through anonymous means. 13 says that a registrar has to provide an anonymized email address or a web form for third parties to be able to contact the registrant. Moving on, recommendation 18 states that registries and registrars must put in place a process to handle reasonable requests for lawful disclosure of redacted data to third parties. Essentially, what this means is that registrars and registries have to put a mechanism in place to receive requests from third parties who feel that they have a lawful reason, a lawful justification for having access to certain redacted WHOIS information. That process has to include a process for receiving such requests, reviewing them, and then either providing that information if the registry or registrar believes they do have a justification in line with the law, or not providing that information. And then finally, I just wanted to highlight recommendation 23. This relates to the UDRP, which I'm sure a number of you are at least familiar with, if not having actually used it yourselves. And what recommendation 23 effectively says is that it will allow a complainant to file a UDRP without knowing the contact details of the respondent in the case where the respondent's information might be redacted in the public WHOIS. Once such a UDRP has been filed, then the UDRP provider can provide that the respondent contact details to the complainant. So just in summary, I think what these recommendations say is that they're largely reaffirming the key elements that we've seen in the temporary specification. So what you've seen in the WHOIS for the past 9 months is going to be maintained in the longer term. So that's probably going to include any difficulties you might have been experiencing in your brand protection work, insofar as that relates to the WHOIS. So now I'm going to move on to phase 2. So now that the phase 1 work is complete, the EPDP working group is going to turn to tackling phase 2. As I mentioned earlier, the main scope of phase 2 is to deal with attempting to develop a system for standardized access to certain redacted WHOIS contact information for third parties. Now, I would say that this is definitely the most important aspect of the whole EPDP for brand holders, people that are involved in brand protection, as the hope is that the work that comes out of this is going to actually define process and criteria for third parties to obtain certain redacted WHOIS data. So I think this is going to be absolutely critical for anyone working in the area of brand protection. So that's the core kind of work item of phase 2. Phase 2 is also going to deal with a couple of additional items that were deferred from phase 1. Then they are mainly the more contentious items from phase 1, but the working group felt they didn't have enough time to actually resolve by the kind of short deadline. The phase 2 work hasn't begun yet. They're having a short quiet period before they pick up again. There's a slight added complication that they need to resolve before they start that work, and that is to find a new chair of the EPDP working group. The previous chair, Kurt Fritz, resigned at the end of phase 1. So they've put out calls for expressions of interest in that chair role, and they're hoping that recruitment process will be completed by mid to late April. So I wouldn't expect to see the phase 2 work begin until the end of April at the earliest. And I wanted to finish by showing you all a nice timeline of how the phase 2 work is going to be scheduled. Unfortunately, I'm not able to do that. We don't have a timeline for the phase 2 work yet, essentially because phase 2 haven't begun their work, so they haven't actually got to the point where they've scoped out a work plan and then been able to draw out a timeline from that. The one thing I would say on timing of the phase 2 work is that during the initial planning discussion for phase 2 that took place at the recent ICANN meeting, there was some disagreement between working group members about exactly how quick that phase 2 work should proceed. Certain representatives from the intellectual property area were kind of understandably keen for that work to progress as quickly as possible, and they seem to be wanting to progress more quickly than some other members of the EPDP working group. I mean, that's understandable in the sense that people working in the front of intellectual property and brand protection, they want to have a process and a mechanism for attempting to obtain redacted information that they feel they have a legal justification for as soon as possible. But yeah, as soon as this work plan has been drafted and they have some semblance of a timeline, we're going to be providing updates on that. So we'll keep everyone abreast of important developments. And with that, I'm going to hand back to Jeff Newman.
Hello, thanks, Ashley. I know we were just talking about the EPDP, and it's a good segue into the PDP as a process itself. And I know this is the part that everyone's can't wait for, the most exciting part of this webinar. But it actually is a topic that's very close to my heart, and that's something I've been involved in for the past 20+ years in the ICANN community. And so over these next couple slides, we're going to be talking about the policy development process and ICANN governance in general, and the different efforts that are currently underway in order to improve the multi-stakeholder model. So just to take a step back, the PDP refers to the policy development process by that is performed, I guess, in the generic name supporting organization of ICANN, and it's the primary means by which the ICANN community can develop and implement new policies for generic top-level domains. This also can impact, in certain circumstances, if it deals with certain issues, it could greatly impact the contracts that registries and registrars have with ICANN. And it's the one mechanism that can be used to implement new policies and contractual provisions outside of the complete control of the contracted parties and ICANN as an organization. So it is extremely important to contracted parties to have a policy development process that not only considers the needs of the contracted parties and the non-contracted parties, but also is efficient and can be utilized to address the issues such as Ashley was talking about with the EPDP, the expedited PDP, dealing with new regulations and laws that came out in the European Union, and that's just the first of many that we'll see over the coming months and years. So the title of the slide, as you see, is called PDP 3.0, and it seems to be a very big buzzword within the ICANN community, implying that it's a third version or revision of the policy development process. And for reasons I'll talk about later, it is not really a wholesale revision or overhaul of the policy development process, but more just enhancements and clarifications. So if it were up to me, I would probably call it PDP 2.5, but it's not up to me. It's already called PDP 3.0. So what are the issues with the current PDP that's in place? Well, many people have argued, and rightfully so, that policy development process takes an incredibly long amount of time. Several years is the minimum time frame. That a number of working groups get bogged down in terms of bureaucracy, in terms of sticking to their silos and not actually wanting to come to a consensus on certain issues, and in fact, in some cases, benefit by delaying the activities of a working group. Another issue is that the community is talking about our working group leadership, or deals with working group leadership. Some leaders are pretty effective in dealing with their working groups and keeping conversations moving along. Other working groups have not had the similar amount of success. And although I am a co-chair of one of the working groups at this point, I'm not going to comment as to whether the community believes that the one that I'm on is efficient or not. I'll let others make that determination. In addition, there's been an increase in the complexity of subject matter. So as Ashley was talking about, the EPDP deals with so many complicated issues involving the needs of complying with legislation, the needs of law enforcement, the needs of intellectual property owners and enforcing their brand, and that's all balanced against the right to privacy and the goals of the European legislation to begin with. And that is not an easy subject to work your way through all the extremely complicated legal and other issues. And finally, another topic that has generated a lot of controversy is, what is the role of the GNSO Council in managing the policy development process? When should it step in? When should it step in? Can the council substitute its own views for that of what a working group ultimately comes up with? So if you go to the next slide, the outcomes thus far, and this is a personal opinion, have been pretty much cosmetic in nature and only incremental improvements. What has been done so far is, and what's being implemented over the next several months, are things that will clarify the role of a position called the GNSO Council Liaison, which will hopefully allow the council to more effectively manage the workflow and timelines and activities of a working group. A written description of the roles and responsibilities of working group leaders, recommendations to actually enforce milestones and deadlines, reviewing working group leadership, and if possible, to have an independent conflict resolution facilitator or facilitation available in cases where groups are stuck on trying to reach consensus. But these incremental improvements, in my view, do not address the real issues that ICANN has currently with its multi-stakeholder model. It really doesn't solve the biggest issue, which in my mind is the lack of incentives for people that participate in working groups to actually come to consensus on issues and to work together to find the best solution for the community, as opposed to sticking to original positions or their own silos, as it's often called. So if you go to the next slide, the ICANN board has also recognized that in addition to these improvements to the policy development process, there's also a movement to work on evolving the effectiveness of the multi-stakeholder model. And this was announced in Kobe at the last ICANN meeting during the opening ceremony, and has been really a pet project of the current chair of the board, Shireen Chalabi, and I think it's a welcome program and initiative, and I think I think it can go a long way in helping to make the organization more effective. This is going to be a two-phase project, which will take the entire year. The first phase will be to develop the list of issues that need to be addressed. The second phase is then to create a work plan to include ways to address these issues into the next operating plan. The outline of the work plan will hopefully be delivered in Marrakesh at ICANN 65 in June, and a final work plan by the end of the year. And as we change the slide, it is important that the work does not replace other things that are going on within the community, including this PDP 3.0 that we just mentioned. So what are the list of issues that they already have from previous meetings, which is now currently being built upon, but also prioritized, and will, I guess, set the basis for this outline of the work plan in Marrakesh. The one I mentioned earlier about consensus is on there. You'll see, again, that's the inability or the lack of incentives for different groups and organizations to come together and compromise. The costs of actually participating in the ICANN process, and if you want to go to these meetings, which are all around the world, it's very difficult unless you have a company that's willing to pay for it, or you qualify for some of the few spots that ICANN has for travel funding. Volunteer burnout has definitely been an issue over the last several years. There's always some issue of the day which attracts everyone's attention, and then like the EPDP, as Ashley was talking about, but before that it was the accountability reforms and separating from the Department of Commerce. Before that, it was the last round of GTLDs. And it seems like there's always some issue that takes up everybody's attention. So by the time that they try to focus on items that are needed for ICANN's daily mission, volunteers feel very burnt out. And the last one I'll highlight there is the issue of silos, where people participating in the ICANN model are often benefit from staying in their silo, from not deviating from their original position, because in their minds, if they do compromise, they may be in a worse position than when they had started this discussion. So those are just some of the items. I didn't talk about everyone on there, but these are certainly, this list will more than likely grow over the next several months, and hopefully the community will prioritize those. And I really believe that these are the core issues of what ICANN is facing, and what really needs to get people working on in order to have this multi-stakeholder model last beyond the 20 years that it's already been in place. So I think with that, I'm going to hand it back to Dietmar to take some questions.
Thank you very much, Jeff. That was very kind of you. So we have run out of time, but if you will indulge us, we do have a question that we would like to pose to Susan with regards to the rights protection mechanism. And the question is it too late to join the Sunrise discussion? Susan, if you'd like to take that one.
Yeah, thanks, Dietmar, and thanks to Scott for that question. It's not too late, but that's a cautious not too late. The work of the Sunrise Group and the claims groups, the two subgroups that are working to develop recommendations at the moment, those subgroups are closed now. I know this for a fact because someone attempted to join this week and was told that they were too late because the work is too advanced. However, those groups will be whatever recommendations come out of those groups will have to go back to the full RPM's working group, where there'll be discussion, because it's for the full working group to adopt and take forward any recommendations coming out of those subgroups. So if you aren't already a member of the RPM's PDP working group, it's certainly not too late to join that, and you should certainly feel able to do so. In addition to that, there is a sort of odd process underway at the moment, whereby members who aren't members of those sub-teams but who have particular recommendations that they want to suggest as proposed solutions for either the Sunrise or the claims can feed them in to the sub-team for consideration. And that's open at the moment, but actually that process, that time for submitting what's effectively individual suggestions is closing tomorrow. So if you have a specific solution that you were thinking of when you asked this question about whether you can get involved, Scott, you may want to submit something via that process. And in fact, if you're not a member of the RPM's working group, I could forward you the details of how to submit that, but you would need to, I think, join in order to make that submission. So I hope that helps. Obviously, leading on from that, there'll be a public comment period. And so lots of opportunity for members of the community who haven't been in the working group to express their views.
Thank you very much, Susan, for that very in-depth answer. Thank you very much. Unfortunately, we have run out of time, so we will respond to those people that have asked questions, and we'll get back to them with some answers. And it's just left for me to say thank you to everyone that joined the call today. And if you do have any additional questions that you haven't submitted already, please feel free to email experts@valideus.com, and we will then reply back. So again, thank you very much. I hope everyone has an awesome day today, wherever you might be, and thank you very much for joining. That's the end of that one, everyone. Thank you.